Welcome to Clue, Criminal Law for UK Enforcement. Can the police arrest someone, take them away, and then release them with no charge? It sounds strange, but this happens every day under an old common law power called breach of the peace. It's not a crime, but it gives officers the power to act fast when violence is about to break out. Today's lesson explains exactly what it means, when it applies, and how far that power really goes. A breach of the peace happens when harm is done or likely to be done to a person or their property, or when someone fears being harmed through violent or threatening behavior. It is a common law power, not a criminal offense, meaning there is no charge or conviction. The main goal is to prevent harm, not to punish behavior that has already happened. Points to prove. To show a breach of the peace exists, 3 elements must be present. 1. Actual harm to a person or property, or a clear risk of harm. 2. Conduct that causes another person to fear such harm. 3. A disturbance or threat serious enough that police intervention is needed to restore peace. If these conditions exist, the power to arrest or detain becomes active under common law. Harm or threat of harm. Harm means physical injury or damage to property. A threat of harm means behavior that could quickly lead to violence, such as raising a fist or smashing objects in anger. The risk must be real and immediate, not just rude or unpleasant. For example, shouting aggressively at someone while moving toward them could amount to a breach if violence is likely to follow. Fear of harm. Even if no one is hit or property is damaged, a breach can still occur if a person reasonably fears they will be harmed. The test is about perception and context. For example, 2 people shouting and advancing on each other in the street can make nearby witnesses fear violence. That fear alone is enough to justify police action under this power. Disturbance or alarm. A breach often involves a disturbance that disrupts public order or causes alarm. It does not need to be a riot or a large fight. One person's violent or threatening behavior in public, or even on private property, can be enough. The focus is on maintaining peace and preventing harm, not waiting for someone to get hurt before acting. Not mere words. It is important to remember that not every argument or insult counts as a breach of the peace. Swearing, name-calling, or loud disagreement, without any threat of violence, is usually not enough. The law focuses on conduct likely to lead to violence. This distinction protects free speech while allowing police to intervene when safety is at risk. Police powers. Police officers may take reasonable action, including arrest, to stop or prevent a breach of the peace. The power applies anywhere, including private homes. Officers can also arrest if a breach has already happened and is likely to occur again soon. Once the threat has passed, the power ends immediately. Continued detention after that point becomes unlawful. Temporary detention. A person arrested for breach of the peace is not being charged with a crime. They are detained temporarily to prevent violence. Once calm is restored, police must release or de-arrest them. De-arrest means the arrest is cancelled and leaves no criminal record. Keeping someone longer than necessary would breach their right to liberty and may amount to false imprisonment. Case law. In 1982, Stephen Howell got into a loud argument outside a house party in Sheffield. Police arrived to find him angry, but no one injured. They arrested him for breach of the peace, even though no crime had been committed. Howell argued the arrest was unlawful, but the court disagreed. Judges ruled a breach occurs when harm is done, or likely to be done, or when someone fears such harm. Recap. A breach of the peace happens when harm or the threat of harm causes fear and disrupts public order. It's not a criminal offense, but police can arrest temporarily to prevent violence. Once calm returns, the person must be released. This power helps keep the public safe, but must be used fairly, proportionately, and within the law. Breach of the peace always ends when peace is restored. Related offenses. Breach of the peace often overlaps with other offenses, such as affray, assault, and public order offenses under the Public Order Act 1986. The key difference is that those offenses are criminal and punishable, while breach of the peace is preventive, used to stop violence before it happens. For a full breakdown, watch our video on public order offenses for a better understanding. Thanks for watching. If there's a legal topic you'd like us to break down, drop a line in the comment section below. We're here to make the law clear, practical, and easy to understand. If this helped, give it a like and hit the subscribe button. Stay tuned for more videos. Keep learning, keep overstanding. Know the law, understand the offense. See you next time.